Good afternoon, everyone, and welcome to one of the last events for 2021. This one was brought to you by the Legal Committee, and we're excited to have all of you here with us today, where what we know will be a great presentation. For those of you who are new to Zoom, we're in Zoom webinar format today, and your tools are found at the bottom of your screen. Unless you are a panelist today, you will not be able to be seen on your camera or use your microphone. And panelists, do keep in mind that while you have your camera on, that we can all see you. So just a little reminder there. Also, down at the bottom of your screen, you will see a Q&A box. When we get to that portion of the event today, please do type your questions into the Q&A down at the bottom so that our co-chairs can call you out to ask your questions. And this event is recorded, and you'll be able to see it on the members only portal later on. So now, without further ado, I'm going to pass it over to two of our legal committee co-chairs, Counsel and Eric. Please take it away.
Thank you very much, Heidi. Good afternoon, everyone. My name is Eric Meyer, and I'm a legal consultant in the Bangkok office of the law firm of Tilleke and Gibbins. I'm also a co-chair of AMCHAM's legal committee, along with Counsel and Chris Knight, Kevin O'Neill, and Doug Mansell. And on behalf of the legal committee, I'd like to welcome everyone to what we believe is going to be an interesting and informative session on class actions in Thailand. So as you'll hear more about from our speakers today, Thailand's class action law was enacted 6 years ago in 2015. And at that time, there were a number of articles and presentations in Thailand's legal community that outlined the new law and speculated on what things might look like going forward. Questions like, would plaintiffs and their lawyers actually use this new type of action? What kinds of cases would we see? What kinds of classes would we see? How would the courts treat these classes? How would the courts treat these cases? What kind of outcomes would we see? And so 6 years later, the courts haven't exactly been flooded with class actions in Thailand, but there's certainly been a number of them over the past few years, and enough to give us at least some idea of how these questions are being answered and how things might continue to develop going forward. So when thinking about events for legal programming this year, we thought it would be a good time to have a session to provide a look back at the law itself, and also to provide some more insight on what we've seen so far with class actions in Thailand, and based on that, where things might go from here. And so with that, I would like to introduce my fellow legal committee co-chair, Counsel, who will introduce our speakers.
Thank you, Captain Eric. Today we have two guest speakers, and please let me introduce our first speakers. Suruswadee Jaimsuwan, who will give us the presentations on looking back at the law, including the basics, the development, and the designs of the law. She is a senior litigator in Tilleke and Gibbins Dispute Resolution Department. She represents clients and provides legal advice on both criminal and civil cases, and of course, class action. She is a former judge of the Thai Court of Justice. And next is Robert Tang. Robert Tang, who will give you the information of the class action in Thailand and will provide you with the real world examples. She is an English qualified lawyer and also of Counsel of Litigation and Regulatory Department of the Piper Bangkok office. I'm very sure that today we are going to get a very good presentation from both guest speakers, and then I will pass over to Suruswadee. Thank you.
Thank you, Eric and Counsel. So let's begin with our presentation, and I think our presentation is up already, right? Okay, it's about to be up. Here, class actions in Thailand, a look back at the law, a look ahead at potential trends. Today, Robert and I would like to talk about class action in Thailand. This presentation is divided in two large parts. The first bit would be me providing you a look back at the law, giving you a perspective of what this law is about and why is it one of the most powerful tools in the Civil Procedure Code. And then Robert will then provide you the news of how this law is picking up popularity in Thailand through the trends and of what is happening now in the world of class action. Also, he will be giving examples of how this law is being used in Thailand. So next slide, please. This is our photos, and the next one is our agenda. All of these would be divided into 5 sections. The first bit that me and Kun Robert will be talking about will take about 40 to 50 minutes. And then we will leave the end around 10 to 15 minutes for Q&A to provide you with this general idea of the law of how it works in Thailand. So let's begin. Next slide, please. To understand how class action law is being used in Thailand, it is useful to know a bit of its history and how it's designed to do its work, okay? So this is the looking back at the law part that I will be assisting you with. Next slide, please, the basics. Before we dwell into those details about the law, let's not leave anybody behind here because I checked the attendees list and some of us are not lawyers. So let's start with the basics of what are we talking about today. Today, we're going to talk about a special procedural law. Procedural law provides rules on how the court handles case proceedings and how parties are to present themselves in courts, okay? There are different procedural laws for different types of cases, such as civil cases, they have their own procedural law. Criminal cases, these cases have its own criminal procedural law, and consumer cases, okay? So different types of cases would be handled differently simply because of these different sets of rules being procedural law, okay? In normal cases, not class action cases, generally speaking, there is no limitation on the numbers of parties in one case, okay? Any type of case is not limited to having one plaintiff or one defendant. You can see that it's not uncommon to have numbers of plaintiffs and or defendants in the case. It can be as many as hundreds. So in these normal cases, only the parties of the case are bound by the judgment, not others. Okay. What we are talking about today is a special law. Class action procedural law is special, and because of this, the general procedural law may not be applied to certain areas of class action cases, such as a class member who is not a direct party in a case can be bound by a judgment without having to act or do anything. This special law allows one person, the representative, a named plaintiff, to commence an action that would bind other people, which are class members, without even having to interconnect, talk to each other. No POA is needed at all. Okay. So this means that one person can provide this kind of proceedings for other class members without having to be involved or talk to each other at all. So one win may equal to many wins altogether. You can see now that the class action law is not a type of substantial law, but a procedural law. It does not provide rights or duties among the parties per se, but it's just a set of rules that tells one how to handle these cases, okay? And this particular rule is unique. So, life before class action law in Thailand, complaints could be filed by multiple parties according to the civil procedure law. However, the class action law in other jurisdictions was seen to provide more economical benefits for particular types of cases, such as matters in relation to interests of the less privileged. So this class action concept was adopted and adapted to be part of the civil procedural law in Thailand. Okay, so next slide, please, the development. It started out as a bill on class action for securities proceedings by the SEC, the Securities and Exchange Commission. But the bill caught the Civil Procedural Code Revision Committee's attention while it was being reviewed by the Office of the Counsel of State. Because this very concept of class action could be beneficial for other cases as well, not just securities and exchange related claims. So this project was later supported by the US Agency for International Development, USAID. And there were dialogues between Kinan Institute Asia and American Bar Association and Thai lawyers. So Thai and US lawyers exchanged views on the bill to amend the Civil Procedure Code itself. And not long after, the National Legislative Assembly passed the law, next slide please, which is named the Act to amend the Civil Procedure Code number 26, BE 2558 in the year 2015, and we call now it the Act. And this Act was effective since December 3rd, 2015, which is 240 days after the publication. The Act added a total of 49 sections on class action to the Civil Procedure Code, as compared to the Rule 23 in the US. It's quite a long portion, a lot in the Procedural Code. Next slide, please. So what is class action law is designed to do here? Of course, it's not a copy from the US law, but it was adopted and adapted to fit Thai procedural law. So it might be quite different from what you have in the US, okay? But the design, I think the key concept somehow reflects the one that you have in the US, definitely. The first key point is that it's designed to initiate lawsuit on behalf of a number of injured person by a class representative appointed to act as a named plaintiff. This is the very number one point that I would like to make. To kickstart this class action case, the named plaintiff, the representative, would have to make his case of why the case should be handled as a class action case to the court. The named plaintiff must submit the request with his complaint at the very beginning, okay? The court would then first decide whether to proceed as a class action case or not before the court consider the merit of the case. On this particular point, to certify a class action case, the court must be satisfied through the plaintiff's petition and presented witness of the 4 prerequisites that I will demonstrate in the next slide. During this proceeding, the defendant can argue and the request, can challenge the request and present his evidence as well. So it's like having a case before the case, okay? The first test is that numerosity. Is the class so numerous that joinder of all members as a common case would create difficulties and inconveniences? Thai courts have this benchmark that there would have to be difficulties demonstrated within the Civil Procedural Code, such as difficulties in plaintiffs being joint plaintiffs. Is there any difficulties combining the case together, or reviewing the petitions set under section 57, for example? The fact to determine whether this is numerous enough would depend on the circumstance on a very case-by-case basis. Questions to be asked would range from whether it is practical for each member to file their case separately on one's own to the size of the class. Please note that the number is relevant but not determinative. It's not like in the US that there is a certain number set here. There is no certain number set in Thailand. So other factors that the court would take into consideration would involve the class geographical distribution. They're all over the country or just simply 10 or 15 houses close to each other, okay? Ease of identification and location of class members, knowledge and sophistication of the members, for example, the size of these individual claims, if it's minimal, is it huge, the claim, is it natural if these people will come to the court by themselves instead of doing it through class actions. The nature of the cause of action, it could say that the rule of thumb here is whether class action procedure is superior to other available methods to fairly and efficiently adjudicate the case. That's what the court will have to decide for each case, okay? This discretion of the court of the first instance is only reviewed once by the appellate court. Having said this, it is only logical if the appeal court would limit itself to reviewing the legality of the class certification rather than the facts of the case. However, if the matter of the fact is obviously taken wrong, or there is an abuse of discretion, and the Court of Appeal may insert its view on the facts as well. The second point that must be made is commonality. I think you can see in the slide there. There are questions of law. Is there a question of law or fact common to the class? There has to be a definable class here. It cannot be just anybody to be included. There have to be questions like, have they suffered the same injury, or have they suffered a violation of the same provisions of the laws, and whether their claims depend on a common contention that is capable of having a class action resolution. So in short, the court would ultimately see if it can determine whether it can provide a judgment that can resolve all of this in one stroke, okay? However, because section 222/24 only allows subclasses due to difference in compensation and damage, there is no channel for subclasses in slightly different matters of fact law. So, and also Thai law is silent as to representatives of subclasses. Number 3 here is typicality. The claims of the representative party must be typical of the claims of the class. This is to prevent any potential conflict among the conflict of interest among the members. And this class action procedure law allows named plaintiff to represent absent class members, right? So the question here is whether the named plaintiff is typical of the proposed class. Number 4 here is adequacy of representation. The court will have to definitely see whether the named plaintiff and this named plaintiff attorney can and are able to fairly and adequately protect the interests of the class as well. It's not just about that plaintiff anymore. It's also about the class member, which I would like to elaborate more on the second point on the design. Next slide, please. So this is the second point. Class action law is designed to have an attorney of the plaintiff to drive the trial proceedings with the incentive of being granted an award of legal fees. So in the event that the plaintiff wins, the court issues a judgment ordering the defendant to perform or pay a sum of money. The court must fix an amount of reward for the plaintiff's lawyer. This reward is to be paid by the defendant, okay? So it's also deemed that the plaintiff's lawyer is a judgment creditor. However, the reward to the plaintiff's lawyer shall not exceed 30% of the money sum to be paid due to the judgment of the case. And on this point, later on, you'll find from Robert Tang's presentation that when this design is used in Thailand, whether this is reflected or not, and he will give you more practical examples then. So the plaintiff is probably paying, but not the very sum of money that the lawyers have their eyes on, okay? So next slide, please. The third point about the design, the key point that I would like to provide you is that it's designed to provide this easy access to justice to the rest of the class as well. Other members, they don't need to get involved from the beginning. If one does not want to be bound by it, one can opt out from it, okay? The very essence of the class action proceeding request is to request the court to provide a judgment that will state the rights of the named plaintiff and also of the class members. The very objective here is for both. So this means all class members are provided for automatically. But how will these other class members know about the proceeding? The request I mentioned that the plaintiff must do from the beginning. after the court allows the case to be handled as a class action case, the court will have to provide a detailed public notice, okay? And the chance to opt out from the case officially starts here. This public notice would have to provide the time frame of no less than 45 days for class members to opt out by way of submitting a very simple request in writing to the court. If this time lapses, the process is more complex. You must provide more reasons, and the court will have the discretion whether to allow it or not. Okay. To put things simply, if you want to opt out, do opt out before the time lapse. Next slide, please. The design on the fourth key point here is that it's designed to have the court to play the central role of safeguarding all class members and the interests of justice, which is a very important role indeed. So it has vast discretion or decision-making power on many aspects of the law. For example, even where the defendant is in default of answer or appearance, even though the defendant does not show up at all, the court shall take evidence ex parte. And it may on its own accord take further evidence if it thinks necessary in the interest of justice, okay? So compared to normal cases, not all normal cases are required to take for the court to take evidence in this way. Secondly, the court can change from class action proceedings to normal proceedings as well. If the court sees that class action proceedings is no longer necessary or no longer adequately protecting class members. So this is, well, each case has its own concern and it's up to the court. Thirdly, the court can replace the named plaintiff's attorney if the court sees that the attorney is incapable of protecting these class members' interests adequately and fairly. Thirdly, most importantly, these cases still, even though with class action proceedings, the parties can still negotiate, mediate, and arrive with the conclusion themselves. But then the court has a very important role in reviewing these compromise agreements or a petition to withdraw the complaint by the plaintiff, or even the request to opt for arbitration. As compared to normal cases, the court will just generally grant those petitions. But in class action, there are things to do, and the court will have to see that all aspects of the law is met. There are short lists of things. So compared to the US, I think the most important part that I see is that the rule of thumb here is whether the class action procedure is superior to other available methods to fairly and efficiently adjudicate these cases. So Thailand is a smaller country than the US, and I think these kind of rules only set the class action law to be less attractive if I compare it to the US. But anyway, before I wrap up everything about this class action law here, let us hear from Kun Robert Tang, how powerful this tool is in Thailand now. Next slide, please. And I trust that he will provide us with very many examples of these cases. Please, Robert, the floor is yours.
Thank you, Kun Suruswadee. Good afternoon, everybody. My name is Robert Tang. As Kun Counsel mentioned, I'm based here in the Thailand office, and I've been here for 13 years, helping businesses resolve their disputes in Thailand and in Southeast Asia. So what am I doing today? Well, I'm going to be exploring the state of consumer class actions in Thailand and putting it into context for you all. And by doing that, I'm going to look at some major consumer class action cases, explore some of the key drivers and threats to adoption of class actions here, and also then explore how ESG is becoming a bigger player here as well in the context of class actions for Thailand and the region. So what you can see here on the slide, just to put it all into context for you, are the breakdown of the class action cases that have been filed here in Thailand since inception. There isn't a central database, so this is based on our own independent research, and we were able to find 15 cases in Thailand which have been threatened, certified, or settled before class action certification. You can see there 60% of the consumer cases arising out of product liability, telecoms, and financial services related issues. And interestingly, the remaining 40% or so is from ESG related issues. So let's put this into context and explore and talk about one product liability case recently that came to judgment. This concerns a multinational automotive company, and the class made allegations that a certain part of a line of vehicles had defects in it. And what they did was then file that class action here in Thailand. They were certified. The case was decided in 2018, and the class were awarded damages of 24 million Thai baht. And remember this as well for the next fact. The plaintiff's attorney fees awarded in that case was only 800,000 Thai baht. And considering what it was just talking about in the context of lawyers being awarded up to 30% of the damages amount or the quantum amount in legal fees, that doesn't seem to be such a big play there in that particular case. The next example concerns a leading Thai cable TV company, and it's a case that it hit close to my heart. So 2017, the cable TV company, with 3 days notice, ceased the transmission of HBO and 6 other related channels from their packages. And that was against MBTC regulations where 30 days were required, notice it was required. This is an interesting case, not just because it concerned me, and I was one of the participants in that case, but the fact that this was the first case that was pushed and promoted by and I use this term quite loosely, one of the first plaintiffs or private practice lawyers, lawyers to push the case forward on a platform called fongdi.com. Potentially, there was about 300,000 subscribers involved. And what they were seeking was a reduction of about 200 to 500 baht of the monthly fee. In that particular case, it was never certified, unfortunately. Their True provided a settlement of about 1,000 True points, which I'm sure you will all know is probably a few cups of coffee or so. But anyhow, it is what it is, and in that case, it has been resolved. The last case that I'd like to talk about in this particular section concerns the mobile phone industry, phone charges. We all know here, everybody has a mobile phone right in Thailand. There's very, very deep market penetration in terms of mobile phone usage. And the 3 major telephone communications companies here had cases filed against them, class action cases filed against them on allegations of overcharging their subscribers. And what they were alleged to have done was, instead of having a per second billing, which they were supposed to do, they were rounding up the fees, the billing fees on a per minute basis, and thus overcharging subscribers. This case had a potentially significant impact on the industry. Just to take, for example, one of the communication service providers had 23 million subscribers. And in the total context of all of those 3 cases that I'm talking about now, there were a total of 90 million subscribers that could have been potentially impacted. And that would have given rise to damages of around about 22 billion Thai baht. So that was a fairly substantial case. Ultimately, though, those 2 cases were denied certification on the legal issues surrounding whether or not it was correct and expedient and proper for a class action to be filed, given the fact that there was a potentially other legal recourse available to those consumers, which I will discuss a little bit later, and which Suruswadee has already explained a bit earlier on. The next slide, please. Thank you. So in this section, what I would like to talk about and explore is what are the key drivers and threats to adoption, or more the increasing adoption of class actions here in Thailand. Well, starting off with the drivers, it's mostly to do with the fact that there is now this propensity for non-profits and government authorities stepping in to act on behalf of communities and consumers. And the second element of the driver is cultural shifts, which is a fairly significant one, actually. So on the first point, non-profits and government authorities. So here we're talking about consumer protection groups, lawyers' councils, public interest groups, including, for example, the Consumer Foundation, which incidentally was the body that actually pushed forward the 3 telco class actions I just mentioned a few moments ago. Amnesty International being a non-profit organization, which are also involved in one of the later case examples that I'll talk about in relation to a sugar plantation issue. And then Lawyers' Council. If you can all think back to July earlier this year, there was a massive chemical factory explosion at a warehouse near Suvarnabhumi Airport. And that caused around about 7-kilometer radius of devastation and destruction to property, both to members of the public as well as to commerce. And the Sumat Pakran Lawyers' Council, which is the local lawyers body, are now looking at grouping together and helping out the community members there and putting forward a class action to help pursue claims and damages against the chemical factory owners. In respect of government authorities, there aren't actually specific, as I understand it, legislative barriers for those government authorities to step in. And these government authorities can include things such as the Consumer Protection Board, the Office of the Trade Competition Commission, the Public Prosecutor's Office. And on that last one, just as a bit of a comparison with the US, there was a class action filed by the New York State Attorney General against Trump University. And in that case, they managed to secure a $25 million settlement. So the fact that you have government organizations or non-profit organizations pursuing these matters, it still can generate results for the class members. On the second point of cultural shifts and increasing social activism, Counsel Suruswadee will discuss more about the Thai cultural aspects which underpin all of these recent developments. But what I will say is this: there has been a significant cultural shift, and that is driven by the increased use of internet, which has allowed us to effectively engage with ideas and send a call to arms to those that are involved, and at a speed that we've never seen before. The power of social media cannot be underestimated here. It is absolutely increased tremendously, probably from the COVID situation that we everybody's working from home, studying from home, and just generally staying at home. But it has allowed everybody to be connected more easily, and that is certainly being a driving factor for a potential increase of class actions here. So just to put this into context, what do I mean? Well, what kind of actions are we seeing? Well, this issue of or this principle of or idea of cancel culture, which I'm sure that some of you may have heard before. And it's absolutely prevalent in the West, and it happens a lot over there, and it's increasingly happening over here in Asia as well. And let's take an example of China. China basketball is a very, very big sport over there, and there is a lot of basketball players or team officials and people related to that sport from the NBA who are making statements of which then have a significant backlash caused against them in China, such that there's political issues, political pressures, people being blacklisted, companies are being blacklisted, games are being shown off or not being shown on screen, and that has a significant impact on the NBA and their team's revenues, for example. So another example is social movements too. Social movements such as the organization during the pandemic of Black Lives Matter, the Me Too movement, recent developments here in Thailand, all of that whilst occurring on the streets in terms of physical action, how they were organized and coordinated occurred online. So in terms of a threat, if I may talk about that now, one of the main threats is this issue about the legal point that Counsel Suruswadee mentioned earlier about this tension between a consumer case and a class action case. And the fundamental criteria about having a class action having to be the last option of resort, and to take into effect that the proportionality of all of it. In the telco cases I mentioned before, there were two cases were denied certification for this very reason. The courts in those cases found that it wasn't enough. The fact that you had consumer protection procedures available under separate legislation, which would have made it easier for those consumers to seek recourse against those telco companies, meant that even though a class action may have been more efficient as a collective action, it wasn't enough to satisfy the fact that it was a matter of last resort. So that tension hasn't yet been resolved. It's only happened in those telco cases, but it certainly could be something that could impact the the adoption of class actions further. The second one is in relation to incentives. So I mentioned before about that automobile industry case. And in that case, they're only awarded $800,000 of damages. Now, when you compare it to the US system, there is a much more active and much more lucrative plaintiff's bar, so to speak. And it's just not happening here for cultural reasons. It's traditionally for Thai courts here, from what I understand, they don't seem to tend to like to order significant costs and legal fees, etc. And so without that, it's unlikely to be the case that you're going to have a well-developed plaintiff's bar like you might see in the USA. And that could be an impacting or a factor that could kind of slow down the adoption of class actions here. Next slide, please. So moving on to SESG and class actions. So what do we mean by that? Well, apart from SESG being a tongue twister for me, SESG, well, the S in that stands for sustainability. And that means the ability of a company to create value in the long term. The ESG, can be thought of, let's say, for example, as a social credit score that's given to companies. And that score is graded on 3 criteria. Environmental, which concerns with the way that a company engages with the environment, such as the company's pollution track record, emissions output, reliance on particular forms of energy, and the way it uses land. Social concerns the way that a company impacts wider society, how it affects operations, impacts the human rights of others, and whether or not it has modern day slavery statements and financial conflicts and the displacement of communities, etc., particularly in the mining industry. And then thirdly, corporate governance or governance, and that concerns the way the company governs itself and how the company runs itself and the systems which keeps itself accountable. And that could be things such as directors' duties, business ethics, culture and values, diversity and inclusion. And what I mean by that is gender pay gap, female representation in senior leadership positions, and so forth. So ESG is concerned with the company's impact on society generally. Having a poor social credit score can often be a sign of risk and exposure. And for example, having a poor environmental score because of a bad pollution record could be an indicator of potential legal exposures to an environmental class action. And I'll provide some of those examples in a moment. And then if in the past your company has used questionable methods, and I must stress, it doesn't mean it has to be illegal, but just questionable. So it's a perception issue. That could also potentially impact or influence the development of a class action on those issues against you. And then thirdly, bribery and corruption. Well, in the context of listed companies, those kind of actions can harm a shareholder's stock values and things like that, to either overvalue or undervalue it, or not undervalue, but overvalue it. And that could result against a class action against them shareholders and directors as well. So next slide, please. So how does it affect you? How does SESG affect you? Well, if you don't integrate these SESG principles into your business model, it could expose you to a number of risks. And what I'll explore now are the main ones being legal and regulatory, litigation exposure, and reputational risks. These risks can be exacerbated by class action lawsuits. And if they're not addressed, they could result in financial losses, of course. But what I would like to focus on is the wider impact. Yes, of course, having faced or suffered with a class action, you may have to pay significant damages, but that is not the only cost to you as a business. For example, if you have a class action with ESG related based upon those principles, you could damage irreparably your investment opportunities by ESG conscious investors. It's absolutely an increasingly global trend here to have that in this, to have what you call so-called green investors, and you could cut yourself off from that kind of funding if you aren't taking these issues into consideration. Your brand and social license can also be impacted. So instead of being seen as a leading market or the market leader in your industry and the market leading producer of these widgets in your industry, you could be seen as using, child labor user or exploitation, slavery, etc. So there are also reputational risks, which also means it can harm your market position as well. So let's put this into context and provide some real world examples. Next slide, please. So let's start with the environmental section first. Let's start with the environmental section first. The first case is Akara Gold Mines. And so this case, the class members were from Peachit and Petrobrine, which is kind of north-ish of where we are. And the allegation against Akara Resources, which is a listed company, is that Akara are engaging in gold mining in the vicinity of the villages. And those activities had caused an environmental pollution, which had resulted in adverse health impacts on those local villages. There was approximately 300 villages involved, and none of them, well, the case is still ongoing. And each resident is claiming for approximately 1.5 million baht in damages, and also for loss of opportunity to make use of those natural resources. The Akara gold mine case is actually a fairly high profile case. It's widely reported in the press, and there are lots of other related litigation, at least at the commercial business level, between the Kingdom of Thailand and the ultimate owners of that gold mine. The next case is the wax garbage recycling centre case. It's again another case affecting a local community, this time in the Ratchaburi province, and it's alleged that the centre's activities had caused or had chemically contaminated the soil and water in the local vicinity of the village. Approximately 1,000 villagers were affected, and were members of the class. And that in that case, it has come to judgment, and the locals have won. The plaintiffs have won. Interesting for this case, the compensation wasn't just a monetary value based upon a figure or a random figure. It was based on the amount of land that the villagers had owned or were affected by the pollution. So damages range from 1,700 baht per rai to 20,000 baht per rai of polluted land. And Wax Garbage Centre was also ordered to rehabilitate the polluted land as well. So moving on to a social example, this is the Hoi Mai and Mitpol case. This is the sugar plantation case, and this case illustrates the fact that just because you are a Thai company headquartered here, although you may have operations in other countries around this region or around the world, you are not immune from this class action regime and legislation. So in this particular case, Mitpol are based here, a Thai company located here, and they had a sugarcane factory located in Cambodia. And the villagers in this particular case have alleged that they were illegally displaced and commenced the class action here in Thailand against Mitpol. You have over 700 families involved or concerned in this class, and the case remains ongoing. The class certification was dismissed at first instance, but then was certified on appeal. And the quantum of the amount currently is still unclear. The case is ongoing. The next case, or the last case I have for you today, is a corporate governance case concerning Energy Earth PLC or Krung Thai Bank. That case. So in that case, the shareholders of Energy Earth PLC is a listed company here in Thailand, and they had a credit facility with the bank. And the shareholders alleged that the bank withheld the credit facility after the bank had discovered that the company had used falsified documents to obtain that facility. Because of the bank's actions, the Thai DSI or FBI equivalent investigated, and the shareholders alleged that they have been financially harmed by this decision. So this is an interesting case because this is not a class action specifically against the company for what they have done. It's a case where the shareholders are seeking to punish the company in reaction to the news that of the alleged fraud committed by the bank. So what this case also shows is that this class action procedure is a versatile tool. It isn't just about damages. It can also be in terms of protecting your reputation, protecting your share values, and the like. What I'd like to conclude in the interest of time is just these few remarks for now. The ESG class action is not a new thing here for Thailand. You can see from the examples I've just quickly gone round through with you all that it has already existed and there are cases filed in that area. You will see an increase though, and that is from the increased social activism and the increased awareness of these issues, which are based on underpinned by the cultural values which just seem to be changing here in Thailand. And on that point, I'd like to pass you back to Suruswadee, who will explain or go into a little bit of a deeper dive into those issues for you to help develop your understanding more.
Thank you, Robert, for your share on the looking forward, looking ahead here. Next slide, please. So looking ahead, I think from you have heard from myself and Kun Robert here, you notice that class action in Thailand is only on the plaintiff side, not the defendant side. So there is no class action on the defendant side. And again, because of this potential use of class action proceedings, it levels up the playing field for the plaintiffs against the defendant, which may be large companies or somebody with big names, probably. But let's say, I think it is well designed for these less privileged to gather up in groups. Like in the Accra case that Robert said, plaintiff each original claim was like 1.5 million per person, but when they gather up, there are like 500 million baht claim in total. So it's quite a powerful tool indeed. But again, the courts are quite conservative on how or whether they would like the case would be handled with these kind of tools. So, and also when it determines on the compensation, the damages, and the reward for these lawyers, they're very conservative. So even though it's picking up this popularity, like Robert has mentioned, but it's going a little bit slower than in other countries, I would say. It's gradually gathering popularity in Thailand. Next slide, please. Let's ask ourselves this. In tackling these issues, I would like to set out questions for you so that we can have our own thoughts on the matter in our own perspective as well. Are we Thais working together in groups better than before? Are we Thais better team players than before? Are we better at volleyball? Are we better at football? Okay. Is knowledge and views exchange easier than before? Like Robert said, the internet, social media is one of the very important means of communication among Thais nowadays. Things can go pretty fast and reaching many types of people at one time, many groups of people. Are we having more and more litigators who are keen on these law, specialized areas, consumer cases, class action cases than before, like 5 years ago? Are we having the same interests in products and services? Are there, is the market now more and more monopolized by a nationwide company? And what can drive class action proceedings other than that as well? And like recently, there's a case filed to the Civil Court. And behind that, in my view, is driven by a political view against the government on their take on the vaccines. So that's our culture in Thailand is changing in my view. I think it's class action law is going to take a very important role in the future, but it's not going to be as fast as in other countries in my view. So looking ahead, I said these questions and I concluded to myself that it will be more litigated class actions in Thailand in the future. Next slide, please. So conclusion, I think from our presentation, Robert and I, you can see that this powerful tool is now available in Thailand since 2015, and it's, I think, gathering popularity, but the information about these cases is scarce. Simply, I think because, and I'm critiquing my judicial ex-employer here, is that the information that about the cases, about these rulings of the appellate court is not very much available. So it's quite hard to gather information, in-depth information on this. Like I said before, that the court of first instance order is only reviewed once by the appellate court, but the appellate court's judgments or orders are not publicly available. So until that happens, if that happens, I think the popularity of class action would definitely definitely pick up speed there. So that's my conclusion. And I think time-wise, I think we should start with the next slide, our Q&A.
Yeah, all right. I just have something to add. Yeah, from the your presentations, Kun Suruswadee and Kun Robert. You can see that people can see the efficiencies of class actions to the extent that people who do not have the deep pocket can fight against the powerful business entities. And the class action, which is initiated by the group of people, will make the business entities to have a concern as well, especially on the brand value and brand image of that company. And people in class actions, they not just make the claim through the court proceedings. They also do the same thing through the social media, which possibly lead to the negative impact to the brand value and brand image of the company. And the company cannot expect that they can get recover within a few days. And therefore, they need to think about this and take it into consideration. And what I have just spoken to you, leading to the questions to the speaker, that do you have any tips or tricks for the companies to protect themselves against the class action? And over to you, the speaker.
Well, Counsel, thanks very much for your comment. I completely agree with it. I mean, like I said during the presentation, it isn't just about the monetary value. There's so much more in terms of the wider impact of class actions against businesses, and I think people need to be alive to those risks. And I hope today's talk can start some conversations within your organizations. You've asked about risk, well, key tips. Well, I think that one of the things, or some things that we probably could do more, is really to identify risks, and you reduce them, and then by reducing them, you kind of address them at an early stage. And so what do I mean by that? Well, I mean, let's keep up to date. Let's keep up to date on what's going on around you. Look at your industry, look at your colleagues, look at your peers, and see what kind of issues they may be facing. I mean, you look at the automotive industry, you look at the electronics industry, they're all selling similar things, and they're all having similar issues. And so being aware of what's going on in your marketplace, I think, is the first thing. The second thing is to understand your consumers, right? Understand what is it that they are interested in. What is their perception of your brand? What is it that they can feel about whether what you're doing is right or wrong on the ESG front? I mean, going online, we mentioned it earlier. I mean, that's quite an easy thing to do. So it's easy to check on that and see and get a kind of like a temperature check on how your brand is being perceived and what might be faced by it. And the other thing too is the learning thing is, if you are a multinational company, I mean, you must have experienced consumers, or you must have experienced business elsewhere, right? So let's say if you have operations in the US or in Europe, see what they're dealing with. And it's quite likely it'll translate over to here. So first thing is to identify and be aware of those risks. And then you can reduce those risks by actually looking at, conducting like an internal audit of environmental issues or social issues, and to see, whether your supply chain is clean, or whether you are complying with local government local environmental standards. So just having a look and reflecting back on your own processes, and to see if there are any gaps. And don't be afraid to go ask for help. There are professional service providers out there that can help you with these internal audits. And so go out and reach for help. That's something that can be done quite easily as well. And then containing the risk too, right? Well, don't ignore it. If you have an issue, or if you see something that's going to happen, well, then you deal with it. It's as I mentioned about social media, you can't just hide from these things. It can snowball, and it can snowball very quickly. So if you do see something that's going to happen, well, you address it. Get your business teams onto it. Get your quality control teams onto it. Your legal teams, compliance teams. You even speak to your marketing teams, and just see how you can deal with these situations, because you want to nip it in the bud. You want to get to it before it actually gets into a bigger point.
Can I have my take on this, Counsel?
Yes, sure.
Robert just provided us very in-depth in the business perspective, and thank you for that. On my point, I think I'd like to divide that answer into two parts. One is to prevent the class action case altogether. Of course, what Robert said is completely correct. And I think Kun Mansel's question here is also a good one, that he says that US is often claimed that arbitration clauses are used to prevent or frustrate class action litigation. And that, I think that's the second bit that I would like to talk about. So to prevent it from the beginning, probably in the contract, or have people agree to arbitration court clause may assist in preventing class action cases. But however, there is no, like I said, the appellate court's orders and judgments are not available. We don't know what the development of class action cases that clearly, but my take is that if you have these arbitration clauses in the contract, and this might provide a way in which that the parties would have to resolve their case through arbitration rather than coming to the court. But I see this right to be heard by the court is a very basic right, and I think the Constitution will definitely provide for that kind of right, rather than so these arbitration clause must be interpreted very strictly, and it's rather an exemption, not a general rule here. So one must go through the law here, and not going to dwell into detail here. So like if it's a consumer case, go through all consumer law, related law, to see whether that clause would be effective or void under the law. There are other acts in Thailand on these clauses that might affect it, such as Unfair Treatment Clause Act. The section 150 of the CCC might affect it. But however, like I said, if there is any loophole, any errors in that clause, if the parties are not agreeing it to the full extent, like they were tricked into it, it's a form kind of contract, I doubt that the court will uphold that arbitration clause thoroughly. So, but I do not view that the court will strike down the arbitration clause altogether, like from the beginning. It has to have other facts to support the court, because like I said, this arbitration act also already allow people to contract out their right to be heard by the court, but then it has to be very strictly interpreted. So I think, do we have any tips and tricks for companies to protect themselves against class action? Yes, and Robert has provided his take on this, and myself answering Counsel. Until we have a ruling from the appellate court or the Supreme Court judgment, then we would be sure, but now we're not so sure. This is my personal view only.
I would agree with that, Suruswadee. So my main area of practice is arbitration, international arbitration, and I can say that arbitration clauses and class actions is a heavily debated area. There is no right answer, I don't think. And just listening to what you just said about the situation here in Thailand, there isn't a clear answer there too. Just as a quick comparative, and I know I've got Eric here as a US qualified lawyer, and I'm not a US qualified lawyer. I do know there is a much more general, broader approach taken by the US system, and does allow, as you explained, Counsel, the enforcement of an arbitration clause to kind of block or prevent class actions from being taken forwards. But then you've got jurisdictions such as Canada, for example, where they've taken an opposite view, where similar to what you just said, they don't want this arbitration clause or a business's practices to deliberately put in an arbitration clause to be an unconscionable act to prevent those from seeking justice effectively, and then they'll strike them down and allow the class action to pass. So you're absolutely right. There is no right answer. It's much very heavily debated, at least in the arbitration sphere, and certainly something that is not easy to resolve.
Before I forget,
unfortunately, I think I see some more pending questions, but I think our time is up with our engaging conversation today. So we just, again, on behalf of the legal committee, a big thank you to our speakers today for our class action webinar. Thank you very much. And Heidi, we'll turn it over to you. Thank you.
Thanks so much. Thank you again to our speakers, and what a great and informative program. And thanks to our legal committee for setting this up for us. You've had an amazing year with a lot of activity. So thank you very much for keeping our members informed. The next program from the legal committee is on Tuesday, January 25th at 2 p.m. with an online event. We're delighted to welcome Kun Pranat Lauparat, partner of Chandler AMCHAM, and he will discuss a notification issued by the Office of the Trade Competition Commission that limits potentially unfair credit terms for SMEs. This session will be particularly of interest to SMEs and those that do business with them. So that'll be a joint event with the SME committee and the legal committee the last week of January. Thank you everybody for joining us for the event today. It's been great to have you all here, and I look forward to seeing you again soon. Bye-bye now.
Thank you.
Thank you. Bye-bye.